In a medical malpractice case, if you fail to disclose certain information to your treating doctor, will it make a difference in your case when you sue the doctor whom you believe caused you significant harm and injury? You want to know the answer? Come join me for a walk around the lake as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The answer is, it may. Now, what do I mean? So now let's say you go to the doctor for a particular problem. And when you go to check in with the doctor, they give you a sheet, an information sheet, and it asks about various history, various problems you had in the past. It asks about your medication. And now, as you fill it out, you're distracted, you're not paying attention, you don't fill it out completely, and by the time you're done, before you actually finish, you're already called into the room. Okay, so now, as you're talking to the doctor is asking you what brings you into his office that day. He asks you how long this complaint has existed, for what period of time, and then he begins to get details about what medications you're on, details about whether you ever had surgery before, details about things in your past medical history that will help him evaluate your current condition and your current complaint. So now there's something in your history that you really don't think is important. You don't think it's relevant. And you intentionally choose not to share that information with the doctor. The doctor now goes ahead and creates a treatment plan for you based upon the information that you did provide to him. And now, during the course of this treatment plan, over a period of weeks and months, instead of getting better, you are actually getting worse. You are getting worse and worse. And you go back to the doctor, not once, not twice, but many times. And the doctor is trying to do different tests to try and evaluate what the problem is. And you're still not getting better. Now, you finally wind up going into the emergency room, you have various tests done, various imaging tests, and now the doctors are finally able to come to the conclusion and reach a diagnosis of what your problem is. Your doctor, your treating doctor at the hospital tells you, hey, listen, did you ever have this condition before? You immediately say, yes, I did. I had this a year ago, and I had the following treatment. And that didn't really help, so I really forgot about it. So now you get a bug in your ear, and someone tells you to find an attorney because you have a valid case, they say. So you go to an attorney, your attorney gets all your medical records, he has an expert review it, and the expert concludes that yes, your doctor was careless. He violated the basic standards of medical care, causing you significant harm and injury. So now your lawyer goes ahead and starts a lawsuit against this particular doctor for all of the injuries, so that your goal is to try and obtain money as a form of compensation for all of the harms and losses and damages that you incurred. Okay, but now let's get back to the question I raised in the title of this video. If you failed to provide the doctor with certain information during the course of your treatment, will it affect your case? And I said the answer is maybe. Now, why is that? So now one of the defenses that the doctor is going to raise is, he's going to say, listen, at no time during any of the visits and any interactions I had with this patient did you, the patient, tell me that you had this particular problem. If I knew that you had this problem, I never would have done X, Y, and Z. I never would have recommended that you undergo this testing. I never would have had you do this particular procedure had I known that you had gone through this particular problem in the past. Now, is that a valid defense? The answer is it certainly might be. If, in fact, you had that information, and the doctor needed that information in order to reach an appropriate decision about what treatment you needed to receive, then the question becomes, okay, if you had disclosed this information, and the doctor understood the significance of this information, would your outcome have been any different? The doctor will argue that, yes, your outcome certainly would have been different, and you would have avoided having all of the injuries that you're claiming this doctor carelessly caused. Now, is that a problem? Yes, it is a problem. Because if that's true, now your failure to disclose certain information to the doctor during the time that you were treating with him will certainly have affected his ability and his decision-making process to allow him the opportunity to recommend the best course of treatment for you. So, whether or not this was intentional, whether or not this was simply a moment of forgetfulness, whatever the reason is, the doctor will certainly raise that issue as what we call an affirmative defense in order to defend this case, to establish that he did nothing wrong and whatever he did not cause or contribute to your injuries. In that instance, you are going to have an uphill battle to show that the fact that you failed to tell him about this particular history, medical history, this medical condition that you did not disclose, made no difference whatsoever. So why do I share this quick information with you? I share it with you because this does come up from time to time. And now we have to sit down with the patient and ask, hey, listen, when you saw the doctor for the very first time, did you make the following complaint? And did you disclose to the doctor that you had a history of this particular condition? Oftentimes, now it's been a year, 2, 3 years down the road, the patient, the injured patient, will not recall exactly what they said and what they did. In that instance, now we are left only with the doctor's medical records, which are presumed to have been made at the time that you are seeing and treating him. Now, what are we left with? We're left with the doctor's medical records that indicate you did not disclose that information to him. It's not in your intake sheet, and it's not on any information you provided to the doctor, because the doctor tells me later during the course of questioning that, hey, if the patient had told me about this, it was significant and I would have definitely noted it in my chart. And because it's not there, I can definitely say that the patient did not disclose that information to me. And the doctor will also testify during his deposition that had he known this information, now it would have altered the trajectory of his treatment plan. And he would not have done certain things that in this case he certainly did. You know, I realize you're likely watching this because you want to see the beautiful lake. No. I realize you're watching this because you likely have questions or concerns about your own matter. If your matter did happen in New York and you are thinking about bringing a lawsuit, but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.